Good afternoon. It is shortly afternoon. I will call this meeting of the Legislative Commission on Data Practices to order. The date is February 11th, 2026. And the first order of business will be to approve the minutes of January 22nd. Anybody want to move those minutes? All right. Co-Chair Feist moves the minutes. Any discussion? Seeing none, all those in favor say aye. Aye. Opposed, same sign. Oops, I gavelled in too soon, but motion prevails. Today we're going to get started, and our staff, Nick, has prepared for us a summary of the last several meetings that we've had here during the interim. And I just want to, first of all, thank all the members and members of the public, everyone that's helped participate in these meetings that we've had. I think they've been really informational, fruitful, and insightful. I am very thankful that we did some serious work on this commission. And so with that, I'm going to hand it over to Nick. What's your
Nero.
Nero. Mr. Nero, would you like to present your summary for us? And thank you for putting that together.
Thank you, Madam Chair, members. You'll see in your packet, it is also posted online. I did a high-level summary of this last set of meetings starting in October and going through our last meeting in January. And with each topic, I tried to just sort of highlight what public testifiers spoke about each topic, and then commission members' discussion on that topic. Tried to not come to any conclusions. Didn't want to sort of bias the summary in any way, and really attempted to keep it at a high level of here was the topic and here were the issues. So I'm happy to go more fully through each section, really however you want to spend your time, Madam Chair.
Thank you, Mr. Nero, and thank you for preparing this report. How would members like to proceed? I'm happy to have him go through this in a little bit more detail if y'all want that, if that's okay. I think that would be helpful if people haven't had the time to digest it yet. So if you want to hit the high points, that would be great.
Of course, Madam Chair.
Mr. Nero.
So starting with the October 15th meeting, that meeting largely centered around a presentation from the Data Practices Office in the Department of Administration, and they spoke about the various issues and their work, mostly that there is sort of this balance between getting all of these requests and the increase of data, and members also discussed the modern issues around data retention and maintenance that differs from the 1970s when this was all physical data, and now the vast amounts of online and digital data that have to be maintained or can be seen as government records or not, and the gray area that has created. Moving forward to the November meeting, there were several topics. The first one was modern data privacy best practices around data minimization, retention, and maintenance. And you had public testifiers and government testifiers talking about retention rules and the risk for government agencies to delete anything, and you also had public testifiers speaking to the potential risk for government agencies who potentially keep more information on their systems than is necessary, and you run into risks with then a data leak because too much information was retained. And members also discussed the difficulty of overcollection versus perhaps deleting something that should have been retained. And that members talked about government retaining data because it can rather than it perhaps should. Moving forward to the second point, current challenges with data retention. Legislative Auditor Judy Randall spoke before and talked about the importance of audits and legislative oversight and how much they rely on data retention, and that a lot of audits are going back 3 to 5 years, and so having a wealth of data is really helpful for that work. And then public testifiers talked about the risks with digital records and how they can be destroyed instantly without notice, review, or appeal. An email can be deleted quickly versus paper documents, which probably are deleted more slowly. And the commission members discussed the tension between the operational limits and accountability expectations, and that retention rules are perhaps outdated, as a lot of the Data Practices Act was written in the 1970s and was really styled for a different view of government data than we have today, perhaps. Third was the treatment of geolocation data. Members talked about how hard it is to classify that kind of data. Our public testifiers discussed that, and whether geolocation data is private or how it is classified currently. And members also discussed how an individual's location is a pretty intimate detail, and the risk that exposing that is perhaps something that should be dealt with in law. Moving to the fourth topic of that day, there was discussion of HIPAA, Minnesota Health Records Act, and consumer data privacy. A lot of discussion just on what records those protect and the strictness that Minnesota Health Records Act provides. And government testifiers talked about the difficulty with compliance because of the differing standards that the different laws provide, and that you have overlapping state and federal agencies and laws, and that because all of this is sort of fragmented across law, you have risks of information being disclosed that perhaps shouldn't, or information that is restricted that perhaps would be helpful to share. Number 5 was the automated license plate reader and body camera reporting requirements. There were testifiers talking about challenges with retention, public access, and also the administrative burden of redaction, and also the risk of secondary use beyond original law enforcement purposes. So body camera footage being posted online for some purpose beyond public inquiry into law enforcement activity. And members discussed the volume and sensitivity that this data is collected instantly and continuously, and can frequently involve individuals who are not suspected of wrongdoing or perhaps convicted of wrongdoing, and that tension between transparency and privacy and operational realities, and also criminal justice. Moving to the 6th, which was data privacy and the interplay of state and federal government, that stretched between 2 meetings. Public testifiers discussed the sort of the history of the Minnesota Data Practices Act, and they raised concerns that federal requests for state-held data could exceed what individuals were originally told about their state data, and that can create sort of tensions in sort of principles embedded in Minnesota law, and that speakers were worried whether Minnesota agencies assess whether federal requests align with why the state originally had collected that data. That discussion continued on into the December 11th meeting. Members discussed, we originally had the member discussion on body cameras, and There was a discussion about, again, continuous capture, the high redaction costs, the long-term storage implications of video rather than, an email or a memo, and that mixture of public content or non-public content, and how that plays into transparency versus privacy. Jumping to the second topic of December 11th, there was a presentation from Minute about the Transparent Artificial Intelligence Government Alliance, or TIGA. John Eichten from Minute discussed TIGA and the rapid adoption of AI tools by government agencies, and that, number one, of course, adopting those is a huge risk. These are pretty new tools, but they also potentially have a huge upside in functionality. That he stressed that governance has to go beyond traditional IT concerns of security and accessibility and sustainability, and that you also have in these elements of privacy and transparency and accountability that it introduced. So Minute has outlined their guiding principles for AI use, a public AI security standard allowing AI use with public data only, prohibitions on using AI with non-public data, and their own explicit retention of human decision-making authority over AI outputs. And you had members of the public who talked about their concern with AI regulation in the state regarding transparency, accountability. I think it's also worth mentioning here that any standard Minute adopts around AI usage would obviously not apply to the legislature. So if the legislature was interested in its own AI standards, it would need to adopt those itself. And then the third topic, enforcement and compliance with the Government Data Practices Act, including public input on ideas for improvement. There were numerous testifiers. They described enforcement as uneven and often inaccessible, and difficulties with cost, complexity, delays. And then you also had government testifiers who highlighted the issues with noncompliance. Specifically, you had criminal defense attorneys talking about being denied or delayed data, and how that can affect due process rights or discovery rights. But then you also had other government testifiers who talked about the high volume, the limited staff, and increasingly complex data requests, and that compliance failures are frequently about capacity rather than anything malicious. And that there, at least to me, was general consensus that enforcement mechanisms and the data practices request have not scaled well with modern data volume and complexity and the amount government agencies both retain and that an individual can request. And lastly, the January 22nd meeting, starting with member discussion on that topic. And members discussed the issues with voluntary compliance and litigation-driven enforcement of the Data Practices Act, that you have non-binding advisory opinions, a remedy system through the courts, which can be both slow and costly, and that individuals often lack practical tools to enforce their rights and have to either turn to other government agencies like the Data Practices Office for help or to the courts. And members discussed whether private lawsuits for enforcement and how that serves transparency and privacy goals, while at the same time agencies legitimately have capacity constraints. Second, we had the discussion on the BCA's Fusion Center report. A member from the BCA was not able to present, so it was mostly just a review of that report, their data practices, information sharing with partner agencies, and oversight. And members discussed transparency concerns and how data can flow between state, local, and federal government agencies, and how aware members of the public are of that potential flow of data information. Third, Representative Feist presented HF 103, which would be a ban on reverse location information warrants. And she discussed that this bill would prohibit government entities from requesting or obtaining reverse location information, which is it would create a civil cause of action, and the risks that those kinds of searches potentially identify individuals based on proximity, could implicate large numbers of innocent people, and has difficulty reconciling with notice and consent principles when a large body of people is essentially has a warrant out rather than targeted. And then fourth, Representative Feist, if you would like to
Representative
correct me on your bill, please do.
Representative Feist.
Thank you. I just wanted to clarify that it prohibits both reverse location warrants, as well as reverse keyword search warrants. So where law enforcement could just say who all searched for a certain phrase in a window of time. And so it would prohibit that for the same basic policy reasons. Just wanted to clarify. Thanks.
Thank you.
Representative Feist, apologies for excluding that piece. And then fourth, there was a discussion about AI and court records, and members discussed the both possibility and risks of AI and court records. I know as an attorney myself, something that could search and summarize and analyze has incredible potential, but also I think everyone's heard those stories of cases being hallucinated, and with the advent of potential analysis, you have risks of cases being taken out of context or cases being misinterpreted, and then lawyers relying on those out of context or misinterpreted cases, or perhaps hallucinated cases. And the tension that can create between a public court proceeding or privacy expectations if suddenly every case has been digitized and in an AI system, suddenly any court record could be much more quickly accessed than it currently is. And that is this year's data practices. Happy to make amendments to this summary or expand on any of these topics or answer questions, Madam Chair.
Thank you, Mr. Nero. Thank you for summarizing that. I'm guessing that was a little bit of work. You're probably going back and looking at some of the video and different things, or at least listening. So thank you for that. And I don't know if you want it amended. I don't know that we need to make a motion. I don't know, is that appropriate in this commission? He could just do it. Yeah, your bill will probably speak for itself, I think, once introduced. So, or it is introduced as, yep. So, let's see, what do we have next? We have member discussion on all this. We've had some really in-depth, lively conversations on these topics, and I'm interested in members' thoughts on what we've covered, maybe what some of the priorities ought to be going forward. One of the things that impressed me a lot was just the public's interest, government entities. We heard from kind of all the stakeholders, and I just felt that there was an appetite for making some changes to make the Data Practices Act more workable for a lot of people. And the other thing that I noticed a lot of was just the enforcement piece. And if a member of the public feels like they're not being served well when they've asked for some data, it's just really a high hurdle to and costly to go to the courts to seek remedy. So that's one of the issues that I felt we heard a lot of throughout these meetings, but I will open it up for other members to weigh in. Madam Co-Chair.
Thank you. I have a few thoughts. They might feel a little disjointed because I just made bullet points as we were listening. But one of the things that I think is really challenging is the question of data minimization and retention periods. So just like with technology evolving so dramatically since we first created the Data Practices Act. Just what is data and how it's stored, and the quantity of it is just so dramatically different than it was in the 70s. And so I think that's something that we have to figure out. And I guess my second bullet point was kind of the same thing, just that technology has evolved, but our law really hasn't. And I think that that is something that it's really valuable time spent really thinking about these issues. I thought we had good conversations about just sort of the ubiquitous collection of data in so many formats by so many public and private entities, and how that data is shared without our knowledge, our permission, and what that means for us as a free society. I was working on like FLoC legislation, but it turned out lots of people had that concern. So I'm going to let other people take the lead, but looking forward to those conversations over the coming session, because I think we really need to rethink how long we want that data to be stored for and what other protections we might be able to put on in terms of who that data is shared with and for what purpose. I'm on a task force for the first time and it's really great. And so now I'm thinking task forces for everything, which is so like government of me. But it does feel like it's been a really good structure to have like experts and legislators come together in like this very structured sort of time limited way to come up with like ideas and solutions and proposals. And so I just think that would be really valuable around these issues. So just throwing that out there. And then I just wrote in my notes that there was a Super Bowl commercial I really hated. And since I have a microphone, I'll just say like, so it was this AI commercial with these like scouts and they were like, tell me AI, what athlete am I looking for? And I just think that's horrible. Like, and I just hope we like, when you think about like the pervasiveness of the use of AI, like in government, like I don't know what we can do to regulate to say like, use your brain, use your intuition, talk with your colleagues, like think critical thoughts. But I really hope we don't like delegate our role to AI. And I think the last thing, the last specific policy thing is just, I really am kind of excited about the idea of bringing in like the Office of Collaboration and Dispute Resolution and like this mediation into the process of data practices requests. Because I know I've had conversations with people where I feel like you get so bogged down in process. The process is so cumbersome and so complicated and it can be so expensive. And you get like pulled into this like dynamic that is a struggle when actually I think in a lot of cases, definitely not all, but I think in a lot of cases, like both sides are really acting in good faith with like reasonable, important objectives. And I feel like if there was some way that we could infuse more sort of productive dialogue about what it is that the data practices request seeks to understand and how the government entity can respond in a way that is like faster and easier for them, but also gets to the heart of what it is that like we, the public, deserve to know. And so I'm going to be thinking about what that might look like. And lastly, just want to say that I appreciate this commission so much. We are all so different. Like I don't know if you've noticed, but it's kind of a polarized society lately. But this is like this area where like we really do agree like passionately and it's really important. And I think it's often overlooked. And so I've been incredibly grateful to have this opportunity to co-chair with you and to have these hearings. So thank you.
Back at you, Co-Chair Feist. It's been a good journey with you. And, you know, now that you're not going to be in the legislature anymore after this next year, you'll have lots of time on your hands to be part of any collaboration that happens. So, other members' comments? Representative Hudson.
Thank you, Madam Chairs. Just bouncing off of what Co-Chair Feist had to say, starting with the AI question in that Super Bowl ad, I had the same thought. And it reminded me of a conversation I had with a couple of gentlemen actually, who work at a very high level in the AI industry. So they're pro AI, but they're also very cognitive of the limitations and the potential risks and the problems. And I'm sure at least one of them would be happy to come and testify for any sort of legislation that takes AI out of those types of decision-making processes. In fact, that was one of the specific things that they lifted up as a possibility for this session is, and I've done nothing on this, so if you want to take the lead, that's great. Legislation that prohibits hiring decisions based upon AI making the decision. And their rationale for it was AI is very good at certain things. It's very good at looking for data, of looking for information, compiling information. But when you ask it, is this the best candidate versus this person or that person? What you're asking it for is an opinion. And opinions, it's not good at, because its opinions are going to be based upon some evaluation of language as opposed to actually applying judgment and human values to the question of who should be in this role. So there's a potential there for, I mean, I would be interested in looking at that. So there's potential for something like that to move forward. And then I wanted to ask you, if you don't mind, about, and I apologize for not being here for your bill presentation last time. The reverse location data, reverse keyword data, have there been specific instances that prompted you to author that legislation?
Yes. So it's often kind of an invisible intrusion on our privacy rights, but there are examples. Like one was at the bill hearing of like there was a hit and run, and then every single person who like Googled hit and run to see what happened was then swept up into this law enforcement surveillance net. So that's just one example. But the way that the expert talked about it, he's like, it's also not a good investigative tool, and we don't have data that shows that the like dramatic explosion of the use of this type of warrant has led to a dramatic increase in like catching the perpetrator. The way that the expert described it is it's if you are looking for a needle in a haystack, it is increasing the size of the haystack exponentially. So it's not a good investigative tool either. And the stats are like astounding. Like in one jurisdiction, I think it was Massachusetts, it was like a 1,300% increase in the use of these warrants in a 2-year period. And Minnesota, I believe it was like a 686% increase in the use in a recent 2-year window. So they're using them because they can. But in the process, they're surveilling a lot of law-abiding private citizens and drawing them into their investigation when they shouldn't.
Representative Hudson, follow up? Yeah. I do know that there's a case before the Supreme Court that deals with these reverse location warrants. And I believe, if I'm not mistaken, Attorney General Ellison is probably going to be bringing something on the state level on these. So that's out there, it's, and so then we as legislators need to make that, that call of whether, do we wait for the courts to rule? Is that, what's the balance between like interfering with they're going to, I don't know. Or do we just wait for the courts to find it, one way or the other? So something to keep our eyes on. So any other member discussion? Senator Limmer's awfully quiet. I'll put him on the spot. Nothing? You're not biting?
I have nothing to say.
Okay, well, Senator, yeah,
But since you reminded me,
yeah. Senator Limmer, go ahead.
I think after this year, Representative Feist and I will be comparing notes of how well the Data Practice Commission will be operating, because I too will be leaving at the end of the year. But Minnesota's focus on data privacy is a unique one, I believe. And it's one, as I've said before, we strive to protect the citizen, but we try to make government as open as possible so that the public knows what government is doing for them and maybe to them. And I just hope that we can continue going down that pattern. I think it's good for our society and it's good for governing. And so there's a lot of, as AI becomes more and more a common feature, the need for this type of panel to try and understand where government is trying to catch up to, because the private sector is way, way ahead of us. We're leaps and bounds, quantum leaps, and we're just stodgingly trying to catch up. And I don't think we'll ever catch up until we see an abuse. And then, since legislators are more reactive than they are prospective, there'll be a lot of damage in the process.
Yeah.
Sad to say, but that's what we've seen in the past. And I don't see any reason why it would change into the future. But nevertheless, anytime there's a new technology, we kind of are resistant at first. Newt Gingrich would talk about technology increases, and he'd always use the example of whale oil versus petroleum. And well, you're going to put all of the whalers out of business if we stop using whale oil to lubricate machines. But nevertheless, there is a benefit for technology and for advancement. But this is uniquely different. The advent of petroleum at the beginning of the industrial age didn't affect individual lives to the point that data intrusion and data exploitation of individuals can cause. And it could affect generations of families into the future if for some reason there was a breach of someone's information or a falsehood. It could affect marriages, jobs. It could tilt the direction of families for many generations to come. And so that's why it's really, really important for us to really begin to realize our role to be a little bit of a watchman on a wall is vitally important. And I hope the legislature will, other members of the legislature whose eyes glaze over when we talk about data privacy, and believe me, it's challenging for me too, and I'm interested in this type of thing. But nevertheless, it's vitally important for us to understand the role that we have at this time and place.
Right. Thank you, Senator Limmer, and thank you for your years of service and your dedication to this topic. It hasn't gone unnoticed, and it's very much appreciated. And I think, I don't know if you were here when I said this, but I've already asked our leadership for the next biennium that we have a technology and data privacy full committee. I think it's that important. Senator Lucero is with us virtually, and he has his hand raised. Senator Lucero, thanks for joining us.
Thank you, Madam Chair. And continuing on the member discussion, I appreciate the comments that have been made, and everything on this list that was read and reviewed for us, I think is definitely a priority. But I'll draw attention to the very last item on the list, and that is the AI in court records. And so one of the questions or one of the comments I made last session was, and even to the point that Rep. Hudson just made, is having to have a person as part of that process. His context was the employment process. But I can envision a scenario as part of the judicial process, whether it be criminal or civil, where that process will continually be replaced, humans will be replaced with AI in some capacity. That is really alarming and concerning, because it can lead to, if you think of the continuum of due process and all the checks and balances involved in the due process, if humans are not as part of that decision-making at every step, there can be some significant infringements that technology, with its bias, the creators of the technology are going to have embedded bias in it. And that bias can reflect then in the infringing of due process. So I think that topic, and it's not just for the court records, which is the topic at hand, but it's for the entire process, and even going out further, it's for the entirety of government. There is a significant risk as technology replaces humans in the delivery of services, in the checks and balances, in the due process, and then the enforcement of law, that humans absolutely need to be continued as part of that process to maintain those individual liberties and uphold rights.
Thank you, Senator Lucero. Before we get started with public testimony, I had scribbled on one of our past agendas, just some of the noteworthy things that were being said and topics and enforcement, data retention, remedies short of court, convenient use, use the data practices office more. How do we make them, how do we make the public more aware of the resources that they can provide? Prompt reasons for not providing data. They're supposed to provide, or the denial of, I would add to that. They're supposed to provide a statutory reason for not providing certain data, but sometimes they get a little too general and not enough specifics on that. And then just kind of some of the options that requesters and providers of data need to know about, just rolling fulfillment and saying, hey, this is a really big request. Can we narrow it down? And can we, we'll have X amount for you after 30 days, X amount after 60 days, and so forth. So those were just some of the things I scribbled down. And with that, I would like to welcome anyone in the public that would like to testify today. You can take a seat at the table, and then we'll just call upon you as you're seated there. So since we have no, wait, we do have that. I'm sorry. So, yep. Mr. Ealing, go ahead. And then after that, Dr. Newman, and then Mr. Newmeister. So.
Thank you, Madam Chair, Madam Co-Chair. Matt Ealing, Minnesotans for Open Government. I just want to add some summary comments at the end of these series of hearings. First is a thank you. I'd like to thank everyone on this commission for paying such rapt attention to these matters. And particularly because we have two members of the commission who have served with long service and distinction, yourself, Madam Co-Chair Feist, and Senator Limmer, who will be leaving the legislature, our board, and Mr. Wieland here is from our, in attendance here from our board as well. We had a board meeting on Monday night, and our board members wished to pass on to you our thanks for your distinguished service in this area. This is not peripheral activity in terms of government policymaking. This is core to everything else that happens. The public cannot participate in the process of self-governance if they do not understand what the government is up to. And so your focus on that consistently for so many years is appreciated. In terms of a couple other areas I just wanted to touch on briefly, to follow up on Representative Hudson's comments about humans in the loop, and others have mentioned that here as well. This is something that we've been stressing since 2018. At a hearing with Commander Gerlicher, who was formerly with the MPD, we spoke at one of these commission meetings several years ago about the possibility of regulating the use of facial recognition technology. That was where this stuff started to sort of burble up in terms of discussions of artificial intelligence here at the legislature. There have been bills introduced, none have been passed. I think that is one of a series of areas where you're going to find stakeholder parity. For instance, both myself and Commander Gerlicher from MPD were talking about the need to have humans in control of whatever outcome is being fed out of those machines. And so you're going to see all kinds of areas where the legislature can, even if they're not going to make an overarching policy decision about keeping people in the loop, you can look at independent areas like facial recognition technology, like the red light camera regulations that were passed already, where we had a role in making sure that there were humans in the loop of that process. So I would just urge the legislature to continue down that path. I think that's a productive way to address this form of regulation. Also, if anyone is interested, we have spent some time as a board talking about how do you get your arms around AI as a legislative body. And we have on our board Don Gemberling, who was there at the inception of the Data Privacy Act, the Data Practices Act. And the process that was done at that time was to commission a study. How is government using this right now? And we have study language, model study language we've included in our comments before this commission from a couple meetings ago. And so what the legislature did was looked at how government was using those areas of policy at the time, where they were going with them in the future, and then brought that study back to the legislature with recommendations about policy action. Because it's hard to regulate in a vacuum, but you can regulate around what you know. And so holding a study would be extremely helpful. And then the last thing I wanted to touch on is I'm glad to hear there's been additional discussion on data retention and the issues that are flowing from that. When I was here at the very first meeting that this commission discussed that issue at, it was notable to me that there were people both on the requester side and on the government entity side that were asking for more standards around data retention. And so I think that is another productive area where you could find some stakeholder agreement. And there are a couple bills that are moving right now that I think there's not been necessarily stakeholder agreement on those, but I think if you keep working on them, you might be able to find some way to move them forward. One is Madam Chair Scott's bill on the 3-year retention period for certain types of correspondence. And I would just stress not only the importance of that bill as a policy measure, but the fact that in that bill, there is language pulled from existing data retention schedules that are in existence and are adopted and have been adopted by government entities today. So that's where a lot of that language comes from, where that's why the 3-year period is in that bill, because the county model retention schedule has a 3-year retention for certain kinds of correspondence. The municipal retention schedule has a model 3-year retention period. So those things already exist and are already being utilized. So I just want to highlight that because there has been government entity objection to that legislation, which I frankly do not understand because it's modeled on existing retention schedule parameters. That's the end. Those are the end of my comments. So again, just thank you all for the work that you've been doing, and I'm happy to take any questions.
I want to thank Mr. Ealing and your organization. I still say MinCoG. I'm sorry. It just has more of a rhythm to it. Thank you for all of your hard work. The information that you put together is always so thoughtful and factual and practical. And so thank you for that. And Co-Chair Feist, go ahead.
Just ditto, thank you so much for the expertise you bring to our process and helping us come up with the idea in the first place to have like these larger picture discussions. I think it's been hugely valuable. On a totally specific note, do I remember correctly that one of the concerns about Co-Chair Scott's bill had to do with the definitions? I feel like somebody said to me, we don't know if we'd have to keep sticky notes forever. Am I thinking of that bill? Like I feel like part of it was like they weren't sure like the scope of it and that it wasn't specifically about the time period, but about how data was defined.
Mr. Ealing.
Co-Chair Feist, you are correct. Those were the concerns that were raised. The way we look at that language in there is because a lot of that language that's in that bill comes directly out of those existing model retention schedules, which exclude certain kinds of incidental data from being falling within the definition of correspondence, that wouldn't start hopefully to address those kinds of concerns. That is an area that could be looked at further for certain. But I think in terms of the parity between the language that's in the bill and the parity that's how well it matches with what's in the existing retention schedules, that's where I think I have a hard time understanding why there's resistance, because a lot of government entities are using those retention schedules currently as a practical matter. So, thank you.
Thank you. Any other member comments? Well, welcome, Senator or Representative Elkins. Good to see you. Go ahead.
turn on the switch. So I just in time to register one complaint. Okay. Uh, Well, I'm on 4 LCC committees this session. Okay. And 3 of the 4 of them have been able to publish their meeting schedules well in advance in a way that that the members can participate. And I've missed the last several meetings of this committee, particular committee, one that I really, really wanted to be on. And I think where I think I could have contributed to some of the subjects under discussion, but I keep getting the meeting invitations for times when my calendar is already blocked and with things that I can't move. And I've, given complete access to my calendar to LCC staff so that they can, see when I'm available and when I'm not. But in my experience, all of the successful committees are ones that established a meeting cadence at the very beginning of the process, published the meetings well in advance so people could make plans around them. And I just wish this committee operated the same way.
Thank you for that very important comment, and we will work on that into the future.
Because this is a standing committee, we can meet during the session and after the session. And I think we should make plans to do so and make those plans well in advance.
So noted. Thank you so much. And thanks for the times that you've been here. We appreciate it because
I
you've
would-
had a busy interim.
Yes, I've had a very busy interim.
Co-Chair Feist.
Thank you. I so appreciate that. I know that, so I've been on this commission. I don't know if it existed I know it was founded before, but I don't think we did anything my first term, but I've been on it now for 2 terms. And what my experience has been is that we didn't have a lot of convenings, and that a big part of that was trying to make sure that every single person could always make it. And you're one of the most important people. I would like you to participate in all of these because this is you are such an expert. But it felt really important to have a more active commission, and that meant it was more chaotic, and I apologize for that. But I am glad that we were able to meet. I think we met more times this year than we have the entire time I've been in the legislature. And I wish we could be, I agree with you. I just wanted to explain kind of how it happened that way.
Yeah, but there's no shortage of things that this committee should be discussing. There's what's wrong with establishing a meeting cadence and getting them on the dates and times onto our calendar. We might, agree on what the agenda is for a particular meeting, closer to the meeting time, but at least get them out on our calendars earlier so that those times don't get scheduled over.
Thank you. Any other member comments or let's see. Oh, no, that was not a raised hand. Okay, we will move on to Dr. Nauman, and then looks like we'll have Rich wrap it up unless there's some other members of the public that would like to testify too. So welcome, doctor. Go ahead and introduce yourself at the tape and go ahead with your testimony.
Chairs and members of the commission, thank you. My name is Dr. Bibi Newman, and I'm a resident of St. Anthony Village. I appreciate the opportunity to speak with you today. At your January 22 meeting, I submitted written testimony identifying a recurring concern that many residents encounter under the Minnesota Government Data Practices Act. The gap between having a statutory right to access public data and being able to exercise that right predictably in practice. During that discussion, a member of this commission suggested that further consideration would benefit from grounding this issue in research. My written submission today responds to that request. I want to emphasize at the outset that this is not about one city, one request, or one dispute. It is about system design. Across legal and administrative research, there is a consistent finding. Transparency laws succeed or fail not primarily based on how clearly they are written, but on how enforcement is structured. When enforcement depends largely on individual persistence, advisory interpretation, or litigation, access rights tend to become uneven, delayed, or functionally inaccessible, particularly for ordinary residents. What the research shows is that this outcome is not the result of bad intent. It is a predictable consequence of relying on reactive, request-driven models without a reliable post-violation pathway. Over time, that design risks making transparency depend more on resources and capacity than on law. The Commission occupies a unique role in addressing this question. You're not being asked to resolve individual disputes. You're being asked to consider whether Minnesota's data practices framework is structured to deliver access consistently, equitably, and over time. The question before you is not whether transparency is a shared value. We know that it is. The question is whether our enforcement design reliably turns that value into practice. Thank you for your attention and for the Commission's ongoing work.
Thank you, Dr. Nauman. I want to thank you for being here at all of these meetings and for your participation in this subject. It's very valuable and I appreciate it very much. Okay, where'd Rich go? Rich, you want to go? You want to go last? Rich wants to go last. Go ahead and come to the testifiers table. Welcome to the commission. Go ahead and state your name for the record and continue on with your testimony, please.
Sure. Hi, Ben Fishman. May it please the committee chair and members. First and foremost, thank you for the work you've been doing while I wasn't paying attention. So I'm grateful for that. Here's a question I've asked some business leaders. And, you know, Computer Fraud Act aside, I look forward to the cybersecurity committee later today. But how do we translate the values that are embedded in the American Constitution into this revolution? You know, we had the industrial, now it's the fourth revolution. I've asked that question to Lawrence Lessig, Senator Klobuchar, and Brad Smith. I may have stumped the chumps there. So I just want to reassure you, your work is important. There's a bunch of wrong ways to answer the question, and there's no right one yet. Energy policy is top of mind with respect to Commerce Clause. I know that was a case that was heard. So, you know, I think it's best to approach this data issue from the Midwestern heart. You know, Brad Smith's from Appletown, Wisconsin. I'm from Golden Valley, Minnesota. Let's collaborate here so we can have a pro-business result in everyone's best interest. Again, I'm in a bit of a catch-22. So thank you for your time. And I'm excited for baseball this spring to start up again in 9 days. So gratitude. Any questions, comments, concerns?
Thank you, Mr. Fishman. And I guess you've got another, you know, baseball fan here. And it's heartwarming to know that it starts in 9 days. That means that spring is coming. So grateful for that. But thank you for your participation in our commission this year.
You're here.
Anyone else in the audience wishing to testify? Mr. Neumeister, you're up. Oh, while he's coming to the table, I just want to draw members' attention to a follow-up from Mr. Eric Johnson. He was asked to do some follow-up following his testimony in the last commission meeting, I think, and he's provided that to members. So, Mr. Neumeister, go ahead, introduce yourself and go ahead.
Madam Co-Chairs and members of the commission, for the record, my name is Rich Neumeister. As I won't say my twin, but someone who works, I work closely with Matt Elling. Different things. I'm more for privacy on some things. I'd like to just say, I'd like to begin to make some summary comments, the term he used. Details matter. And I applaud you since I was present at the creation of this entity, that you got into some details. And I saw some agreement. I saw some, I don't know. I want to do more things or whatever, and they're all over the board. But one of the other things that I think it's important that we have recognized, and I say we as a people of Minnesota, and because I've been a part of this process for years, sometimes I use the word we, is it's important, and when this was created, that this would also be a way of educating other members. So one of the things I suggest is think of some way or a written comments or with a little bit more detail or whatever it may be to share with your colleagues. Because there will be colleagues out there of yours, they'll say, wow, you talked about that? That's an interest of mine. I mean, that's how, so down in the next few weeks or whatever it might be, something for interim. The other item that I saw of an overall thing is there are some things that you can be busy till the next, for the next interim after session as you prepare, because it's a money session. And one of the things I talked about is take a look at the role of the data practices office. Should we have a board? We have a commission, because one of the things I stated to you is that that entity gets $500,000 already. Because since they've been doing opinions since 1993. And one of the things is, should opinions be binding? Should it be, I mean, these are all kinds of things, but it can also go a long way to clearing up some of the issues that we continually talk about. Enforcement, compliance, you know, whatever it might be. So I think that's one thing. Second, again, technology constantly, as Madam Chair, as Representative Elkins indicated, that whole AI and consumer privacy as it relates all the way to Senator Limmer over the years, you know, has stated and recently about some of the technology. License plate reader is one that this committee dealt with 10 years ago, which brought more to the forefront. And now, if you so choose, because of the information you've garnered, there might be 2 or 3 bills or fixes if you want to do that. That's one of the things that can happen from this commission. The role of enforcement and compliance is all detailed. And for me, as someone who's been here, and I remember, Madam Chair, helping Senator Limmer when he was a representative with one of his bills. First bills was to open up the pardons board. I don't know if I'm sure he was a representative back then, and also has been very much a strong asset for privacy and openness, as Sandra Feist has been over the last 2 terms, I think, that you, 3 terms. So I have always appreciated your open doors and all that. So there are details matter. And so when you hear the concepts of let's do burdensome barriers, you know, let's do this, let's start charging for inspection, all those things that are I can't think of the term, but are things I know will have great impact. They're scary. They're scary to me, and they're scary to the public who, as Matt began this statement, it's important to have access to public data. Because if we don't, you know, as Madison said, you know, it can be a farce or whatever it might be. Information is important for the knowledge of the public. So I want to say thank you very much for your efforts. And I see some things that can happen in the short few weeks that are here. And hold on, we'll see what happens. Anyways, thank you for your time.
Thank you, Mr. Newmeister. Any member comments for Mr. Newmeister? Representative Hudson.
Thank you, Madam Chair. If possible, I'd like to ask a question of, was it Dr. Nolan? Was that correct?
Dr. Nauman?
Nauman.
Is it Newman or Nauman? You've said it every day that you've been here. Go ahead.
I'm sorry, I have soft focus today. I'm looking at the plaque. I apologize.
Hudson.
Hudson.
Yeah.
Representative Hudson. Go ahead.
So my question for you, first of all, I'm very intrigued by your comments overall about enforceability, because that's obviously a problem in more areas than just the one that we're talking about. And it kind of brings to mind some conversations that I've had in a completely unrelated area regarding family law and the enforceability of parental custody times. And I'm wondering if there might be a similar solution. But before I dive into that at all, have you or your associates put any thought into what specific changes need to be made to the enforcement structure in order to make it more effective for people to get the data that they're requesting?
Dr. Nauman.
Thank you, Representative Hudson. I just want to clarify that my associates are my husband and my 3 children, and maybe the dogs count, but I don't know. And so my representatives and myself have not put thought into what that should look like because we do believe that that's up to the legislature. And I'm so sorry that I'm not trying to be flippant. So we have not. We've just brought our issue and done some research around what that looks like in other places and what the problem is that we are running up against.
Representative Hudson.
Thank you, Madam Chair, and thank you for that answer. I don't take it as flippant at all, and I'm encouraged by the fact that you're willing to come here in your personal capacity to express concern over the issue. So, random thoughts, which is usually how I operate on this commission. I think when it comes to enforceability, we often think in terms of, bringing the hammer down for people not doing things the right way. And when it comes to parental custody, that's actually how our laws are currently structured, where if you deny custodial parent time as when you have shared parental custody, my understanding is it's regarded as a felony. And that puts law enforcement in a very difficult position to actually be able to act on that because they're walking into situations it's immediately elevated and escalated. And so one of the things that's been talked about, and I'll bring this back around to data practices, I'm just using it as an example. One of the things that's been talked about is changing first and second offenses to misdemeanor, which would enable law enforcement to go in there and not disrupt the situation, but just say, hey, you're in violation. Here's a ticket. Don't do it again. And then you build this pattern. And then once they hit the third one, now you can have more of a reason to escalate things. And perhaps looking at that as a model to build some sort of enforcement mechanism around this, because obviously we don't want to put our government entities in a position where they're constantly being peppered with the possibility of some sort of heavy-handed legal consequence. But if there was some sort of kind of graduated, hey, you're in violation of this advisory opinion, that advisory opinion, and once you rack up a certain number as an entity, we're going to be looking at some sort of consequence that actually hurts.
I like your creative thinking, and I expect a bill in the coming weeks. No, I think that's a really reasonable approach, to be honest. So I encourage you to pursue that. Yeah. Anyone else in the public? If not, members, I do hope that, and I know Representative Elkins, we may not be able to give you much lead time on any future meetings, but I do think that it would be great to have at least one more meeting during session if we can fit it in. And in the meantime, I'd like to see this commission communicate amongst ourselves too on, hey, I'm going to have this bill. What do you think? And try to build some support around some bipartisan support around some bills going forward that I think will benefit the public and benefit government in general going forward. Senator Limmer.
Thank you, Madam Chair. We had a long list of observations and discussions this year outlined in our notes today. I suggest that we could talk to the prospective chairs of these committees in the legislature to give a brief report to the legislature. That's usually what commissions do anyway. And just review some of the issues that we've discovered by listening to practitioners and it wouldn't have to be all of them, but we could at least highlight some of them to get the legislative members to start thinking about the observations that we've made. I think it would be important, and if we can find a teaching moment for the legislature to listen for a few minutes, I think that would be helpful. And it could also build on the discussion when that legislation does come before the legislature, and it triggers our memories of some of the difficulties that we've heard. We'll start teaching the legislative members about it as well.
I think that's a grand idea, and we happen to be, both of us happen to be, well, there's three of us. All three of us are on the appropriate committee, so I think that's a really good idea for us just to kind of do a presentation, and we can present this summary as well and elaborate on some of the points. And you could certainly do that in the Senate, given your role on the Judiciary Committee over there. So, and Senator Lucero, I'm sure, would be glad to chime in, and Senator Westland. So, any other comments? Chair Feist or Co-Chair Feist, I want to give you an opportunity just to give yourself a wrap or give a wrap here from your perspective.
Yeah, thank you. Well, I've shared some specific thoughts, and we're not done. We're going to have more hearings, but I will just thank Sally and Nick for your support. This is my first time in a chair capacity, so it's been a really great experience. Hopefully it'll be a more orderly experience, but it's just been really great working with you, Co-Chair Scott, creating these agendas, looking at big picture and some specific legislation. So it's been just a really awesome experience. We're not done, but yeah, just thanks for the set of hearings we've had.
I just echo those sentiments. It's been great working with you, and really thanks to all the members for being here and when you can be. And I know it's been a struggle with the meeting times and so forth, but I'm just so thrilled for some active participants in this subject matter. I know a couple of people that were appointed to this commission and were questioning, but I'm like, no, we've got to train the next generation of folks with this. And it is so relevant, as has been pointed out. So thank you to staff. And Nick, thank you. And we'll probably be using you more in the future. We don't want you to get bored over there. So with that, we are adjourned.